Hello, so welcome back to the English law channel, and so we're carrying on with contributory negligence. So that's to say when the defendant is partly responsible for the damage or injury that he or she suffers. Right. So what was I going to say? So contributory negligence is something which is a bit different if there are minors involved. So age is a factor which judges must take into consideration. There was Yachuk against Oliver Blaise Company Limited, 1949, an appellate court case where the defendant sold petrol to a 9-year-old. The child then started burning things as part of a game, and then he sustained severe burn injuries. So the defendant was the person who sold him the petrol, was found to be negligent in selling a pint of petrol to a child. We used to do these things by the pint in those days, because anybody would know that there's a possibility someone will start a fire with it. The boy claimed that his mother had asked him to buy petrol by the pint, which was really unworthy of belief. So there was no contributory negligence on behalf of the 9-year-old, because everybody knows that little children do foolish things. They don't fully appreciate the extent of the jeopardy in which they're placing themselves. There was another case, Goff and Thorne, 1966. So the claimant was a 13-year-old, and she was crossing a busy street. So the lorry driver, he braked and he gestured for her to cross. So she began walking across the street when she was hit by another car, the defendant, who was driving above the speed limit. Now, the lorry driver who'd beckoned her to cross the street was also negligent. There'd been some contributory negligence in the girl because she hadn't stopped to look properly before crossing the road. Anyway, she'd relied on the driver's signal to inviting her to cross. Now Lord Denning said that in a very small child, then you wouldn't say there's any contributory negligence, but an older child there is. By the age of 13, you should have some road sense. So Jackson against Murray 2015 was a UK Supreme Court case. And the Supreme Court, they looked again at contributory negligence. In this case, a 13-year-old sustained some serious injuries when she got out of a school bus and walked into the path of a car and was struck by the vehicle. So there had to be some sort of apportionment of the damages, and contributory negligence was a factor here. Lord Reid had the following to say: "It follows the apportionment of responsibilities inevitably a somewhat rough and ready business. A feature reflected in the judicial preference for round figures, and a variety of possible answers can legitimately given. This is consistent with the requirement under section 1.1 to arrive at a result that the court considers just and equitable." Close quotation. So the round figures, that's why the percentage of contributing negligence is found to be 10%, 20%, 25%. It's not going to be 11.9% or 37.3%. All right, volenti non-fit injuria. Remember that one, if you consent to the action. So it seems blatant that someone who consents to the tort cannot then sue on the so-called tort, but it's not quite that straightforward in practice. So the effect of volenti non-fit injuria, assuming the risk voluntarily, is to absolve somebody of any legal repercussions for any harm or damage that the claimant assumed himself. So the assumption of risk can be something which is undertaken expressly or impliedly, but in either case the defendant has to demonstrate the claimant fully understood both the nature of the risk and how great the risk was. Look at Morris and Murray, 1991, a Queen's Bench case. So two men had been on a drunken debauch. So Mr. Murray suggested to Morris that they fly around in his light aircraft. So they took off, the plane crashed, and it killed Murray, who was piloting it, and it badly injured Morris. So Morris, he initiated an action against the estate of the deceased man. The Court of Appeal said, okay, this pilot was in a crapulous state. The fact that he was inebriated was blatant to anyone. You knew he was blind drunk. Therefore, you, the claimant, were volens. You're willing in that you got into a plane piloted by somebody who you know was in no fit state to fly because he had got himself inebriated. All right, so if a claimant accepts a lift from somebody who's patently drunk, the plea of volenti will hinge on the level of intoxication. Because, does one beer make you drunk? I would say not in most cases. Does 2 makes people tipsy? 3 makes people more so? 4, is that drunk? Probably. But it varies. Some people have got a different tolerance of alcohol based on mass, based on how recently they've eaten, and how regularly they drink, and so on. And how soon after you consume the alcohol do you drive? Is it a minute later? Is it 5 hours later, or what? So people don't usually breathalyze someone who's about to drive them. So in Dan against Hamilton 1939, a King's Bench case, the defendant had driven the claimant to her mother and her mother to see the coronation decorations, the coronation of King George VI, back in 1937, but the case was heard in 1939. So they went to a number of licensed establishments, and it was plain to see that the defendant's ability to drive was seriously restricted because he had consumed spirituous liquor on a considerable scale. Despite imbibing a most considerable quantity of intoxicating liquor, the person said, "Yeah, you can drive me." A plea of valenti was entered, but this was rejected. The claimant was not found to have consented, and this did not absolve the defendant from the negligence on his part. So Asquith was the judge, and he said valenti is inapplicable to this situation because unless the drunkenness is so extreme and so obvious that accepting the lift was something which could equate to walking on the edge of an unfenced cliff. That was the analogy drawn by the bench. So a defence of valenti is now impossible in any action where a passenger brings this against the driver of any vehicle on a public road, but not on a private road. So the Road Traffic Act 1988, Section 149, it voids any antecedent agreement or understanding that a passenger is volens the risk of negligent driving in a vehicle, for which a third-party insurance cover is obligatory. So there, another thing to point out is that knowledge of the risk does not automatically imply consent. Smith against Charles Baker and Sons, 1891, an appellate court case. The House of Lords said that the knowledge of a peril does not always show that you're volens. In this instance, the claimant was hired to dig holes in a rock cutting, and when he was working, a crane swung these stones above him. The employee knew that there was some danger, that the stones could fall and hit him. He complained to his employer, saying that this was jeopardizing him. Nevertheless, he was injured by a stone which fell on him. He brought a legal action against employers, and the employer said, "Well, volenti non fit injuria." But the plaintiff, he knew about the danger. Nevertheless, he persisted in working. He could have refused to work there, but he therefore was accepting the risk. But the valenti argument was thrown out by the court because they didn't accept that carrying on working there meant that the plaintiff was voluntarily assuming the risk. Okay, you might question the logic of that one. How about valenti if somebody is working for another? Smith and Baker shows that employers are alleged to have consented in advance to undertaking a risk of the employer's negligence, where the courts are reluctant to allow this defence of valenti to lie. In practice, employer and employee relationship is one of power. The employer has the greater power. If an employee is not usually in a position to refuse to do particular things, unless he's going to get demoted, possibly sacked. Nonetheless, the defence is sometimes successful in any action by an employee against an employer. Valenti was accepted by the House of Lords, for instance, in ICI Limited against Shatwell. This is what Lord Reed had to say. If the claimant invited or freely aided and abetted his fellow servant's obedience, then he was volens in the fullest sense. Close quotation. That's enough for the moment. Toodle pip.